किसमें After madam. It has been signed, right? You please file an application. We'll do it. Please file an application today. We will list it day after tomorrow. Correct? Give whatever is number, take it day after tomorrow. Please file an application. Because order has been signed, right? Then mention tomorrow, we take it up day after. What referred to because what has happened? Which you mentioned memo. I thought item 1. Or mediation center. Next Lok Adalat will be held after 2 months in September. You want to wait that long? Mediation, right? So, for that side is also billing. Yes, madam. For the appellant. Appellant has not filed the affidavit. They also is not present. We will pass it over, madam. Let's see. But time. What about B and C? The counsel for the petitioner prays for adjournment in order to enable him to move an application seeking service of notice on respondent 7A, 7B and C by publication. When D and E? Yes. The record indicates that respondent 7D and E have refused to accept notice. Therefore, service of notice on them is held to be sufficient. What about these IS? 1 of 22, 2 of 22, 3 of 22 allowed? After service. After service. After service, right? Sir, 3. Harish Kumar MI. Application taken out. He has not filed second settlement. After hearing learned counsel for the appellant, the office objection is ignored. Let the service of notice on respondent is held to be sufficient. They admitted for hearing. Delay is there. Let the appeal be listed for orders on condonation of delay in the next week. So, we will learn it. Government education. For the appellant. This time is granted by way of indulgence to today. Last time it was granted time or what? What?
Not filed application for the dismissed for
Let assets and
non-compliance of office objections, recalling application.
I appeared for appellant place for time for 2 weeks, my lord.
Right.
Serial number
Last time also 2 weeks was granted.
senior is out of session, my lord. Please kindly. Serial number 4, my lord.
The serial number 5, sir.
Oh, sorry.
Last time
You
2 weeks time was granted to comply with office objections on 23/6/2022. However, office objections are including none of the application. 2 weeks further time is granted to comply with office objections, failing which just and dismissed without notice.
There is a recalling application. Yes, to file CD application.
What office objection, Mr. IA 1 of
Second set appeal memo is also not filed.
IA 1 of 2018 shall stand dismissed. Time also granted. You see, the Supreme Court says that in case despite opportunity you don't file, adverse inference has to be drawn. What? See, sort of. Why have you tried like this? These tax. You feel free now. Liberated. 4 weeks time was granted to you. When? So it's the order sheet. I was able to find out. The order sheet, please read. Madam, show him, he doesn't know. Please read this order sheet. Please read. So where is the affidavit? 2 weeks time we had granted, you have not filed. Why? He doesn't want to share his income, right, with the court. So we will draw an adverse inference in that case. Mr. 2 weeks time we are granting you. File it, otherwise we will draw an adverse inference. Correct? That's what we are telling you. Give the file back. What's your name? Learned counsel for the appellant. On 19/4/2023, this court had granted 4 weeks time to learned counsel for the appellant to file the affidavit with regard to assets and liabilities. However, the aforesaid affidavit has not been filed. 2 weeks further time is granted by way of indulgence to file the affidavit as required in view of law laid down by Honorable Supreme Court in so and so. Failing which, this court shall be constrained to draw an adverse inference against the appellant. Correct? For the appellant, what 2 weeks time?
My lord, serial number 7, my lord. Serial number 7. I'm appearing for R. Gopal, my lord. Short accommodation may be given.
You have to pay the process fee, deficit process fee, it appears.
Yes, my lord. Yes.
Memo along with IA.
You have to annex appeal memo along with IA.
Yes, my lord. Yes. 1 week of time may be granted.
have new facilities of knowing the what to comply.
You are aware as to what you are required to comply?
No, my lord, actually, we are not getting the objections. We will be complying within a week.
This facility of appearing through video conferencing does not mean that the court has to tell you what defect you have to comply. Then you will say that I will need 1 week's time. It's your appeal, not court's appeal, right?
Yes, my lord.
We dismiss it. We are not this thing.
2 days.
Don't even know what is you don't even know what we are trying to tell you. You don't even know what objection have to be complied with.
Yes.
And the judge of this court is required to tell you that this is what you are required to do. Then you will say that I need a week's time.
Yes.
You are not obliging this court by complying with office objection. Please understand,
Yes, ma'am.
right?
Sorry, my lord. We will be complying today, sir.
No, there's no question of being sorry. We are only telling you concerned about your attitude, right? You don't know anything about the
Yes.
case, just appear.
Yes.
Week's time, failing which appeal shall stand dismissed without reference to which.
Okay,
Yes,
ma'am.
madam. Week's time. When it counsel for the appellant praise for is granted a week's time to enable us to comply with office objection. Yes. Appeal has been admitted, madam. All right. What's your name? Learned counsel for the appellant. A respondent submits that he has filed wakalat on behalf of the respondent yesterday. Office is directed to delete the name of Mr. So-and-so, Iman and TC, and to reflect the name of Mr. So-and-so as counsel for respondent. It has already been admitted for hearing. Let the same be listed for final hearing. For memo of retirement, madam, please file an application. Please, final hearing. When it was listed for final hearing, the appeal was already listed for final hearing, she says. Final hearing. Let the appeal be on 7th August 20. Council is giving you some sleep. Yes. Objections to so and so. Early hearing. Who has filed this early hearing? Who has filed? Early hearing of the appeal. Has it been admitted? Paper book not filed. Documents will be provided. You don't have the documents of the other side. How did you contest the proceeding before the arbitrator if you don't have?
How you conducted the case when you didn't have the papers?
Then he has to file an application order by which he has been asked to file paper book.
File an application to recall this order.
Which directs you to file paper book. File it. Simple answer is we'll file it. I think that's understandable, right? You are saying all sorts of things. There is an order of the court, right? Saying that asking you to file a paper book. Please file. How can you say that I don't have documents? Same thing we have to tell you. It's not our appeal. We are not concerned with it. We will dismiss it right away. So if you leave it to us, we will dismiss it right away. We are not concerned. There is an order, right? You have to respect an order passed by the court. Order directing, if for some reason you can't file, please say for XYZ reasons I am unable to file paper book. We will consider it. How much time? Last time you did not appear. None for the appellant when the matter is called in second round. We did not dismiss it. This is the urgency. Learned counsel from the appellant based on is granted 2 weeks time to enable him to file a paper book. List thereof.
We have not heard any objections for IL number 1 of 21 for condemnation of delay in filing.
Oh.
This is stated as non-filing of objections to IL.
You don't want to file, right? What is the delay? How many days? Right?
When the better affidavit is filed? Which date the better affidavit is filed? You are not received the copy of better affidavit?
What did you do? You are not a party to the this thing. Order passed by learning single.
Affidavit.
This condonation.
With the disposal of writ petition, third party rights have been created. Pure of whom? After the disposal.
Will issue notice then. Issue notice of IA 1 of 23 to propose respondents. Now, what has happened, right? You have to tell us what is the date of judgment, when did you get the copy, what did you do thereafter, right? Second time. The counsel for the appellant submit that the when that process fee has been paid today. Of a process submission, office is directed to proceed further. And for the appellant, let process fee for service of notice on respondent wanted to be published within 2 weeks. Oh, nobody is appearing. All right. All.
Under the exception is
None. Yes. Valid counsel for the appellant was permitted to retire. None for the appellant, mark his presence. Valid counsel for the appellant was permitted to retire from the case, and thereafter this court on 29/5/2023 had directed issuance of court notice to the appellant. The aforesaid notice has been served on the appellant. However, despite service of notice,
office receptionist shows office receptionist.
not in personal service, right? What is? What do you want to say? It's not a valid service.
Yes, specifically mentioned like
It's not a valid service. Serve, no. Say serve. Right? Despite service of notice, none has appeared. On behalf of the appellant, it appears the appellant is not interested in prosecuting the appeal. The pending interlocutory applications are there, do not survive for consideration. Accordingly, same are disposed of. The result appeal is dismissed for all. The report had heard on IA. Not interested in prosecuting the appeal heard on IA 3 of 22. An application filed on behalf of respondent number 2 and 3. Seeking to withdraw the amount which has been deposited by the appellant for the reasons assigned in the application duly supported. Submitted for the amount. It say not interested, dismiss for on the court. Previous purpose. Yes. No. He has been murdered. Murdered, I was going to say, can you? Are you present? This petition has been filed seeking a writ of previous purpose for action. Son of the petitioner, namely Venkatesh L. Paragraph learned. You are addition. SPP 1 on instruction submits that the petitioner's son has unfortunately been murdered and a first information report in this regard has been registered. The aforesaid submission has not been disputed by learned counsel for the petitioner. Therefore, line below, nothing survives for adjudication in this petition. Same is accordingly disposed of with the liberty to the petitioner. Take recourse to such remedy. Number 16. The Samarth Chenraju.
But they served as a copy of their objections. On a final reminder to this case, make a party led to the time for 2 hours. Okay.
What is it? Your daughter? Huh? Correct. And you provide access to him, that's all. What?
Yes.
Yes. No, he has come from US, that's why we have. Yeah. So, but you can, I mean, it's not a matter to be contested, right? So therefore, you provide access to him, permit him to spend some time with the child whenever he comes to India, that's all. Now somebody needs to.
He has other.
Oh.
There have been certain facts which are being twisted and put to this court.
No, this
about
is-
incident being
No. One thing you should understand, right? We appreciate that you are under pressure to perform because that person is standing behind. This is, we understand that, but this is a matter not to be contested. This is a writ of habeas corpus. Fine, we are not determining in this writ petition, just a minute, the rights of your, this thing, the father of the child. We are not determining in this writ petition. What is the scope of writ petition is confined. Because Honorable Supreme Court has said that it is too late in the day to contend that in child custody matters, writ of habeas corpus is not maintainable. We entertain the petition, right? So what is the scope, you understand? What, I mean, if you want to take away the child with you to US and you want to be his guardian, you know what to do, right? We cannot appoint you in this petition. We cannot appoint you as a guardian. You wanted to see the child. She has come here. You can spend, there is no, this is a fair proposition, no objection on behalf of the mother to permit you to spend time with the child. You can spend time. Thereafter, all we are saying is that you talk to each other. It's not a matter to be contested. Come up with the agreed terms and conditions. There has to be.
There's already a US court on the same custody of the kids. The kid being a US citizen,
No.
immediately brought to India.
No, so you want us to execute that US decree. We have done enough of this exercise before. The orders have been upheld by Supreme Court. We are
permission to file.
No. How much time? How much time?
2 weeks. But if they have to go.
Yes. We mark the presence. Mark the presence.
Well, now the father will
We have-
have the kid in the presence of both the lawyers and education.
Yes. Almost. You can spend 2 hours time. Almost. Yes. Run it counsel for the petition.
Stay at holiday in so
Huh?
it would be accompanied by them to holiday. A hotel where they're staying. And one race was good. Spend time with them.
These things again, you can,
That you can have everything. What should be the venue? What should be the time? This thing. No. Like you file a writ of habeas corpus, the court should issue a direction granting you visitation rights at the place of your convenience, your choice, time. What is this?
So then how do
And this is, we have told you, Mr. Clearly, you should pray that this court doesn't come up before me. Otherwise, we have taken a view that we are not the executing court. High Court of this country is not an executing court in respect of an order passed by the foreign jurisdiction. We have taken the view, it has been upheld by Supreme Court. If you are under a misconception of law that you will execute an order passed by the US court or your appointment as a guardian,
But you're not.
we will at the outset, we tell you that it is a thoroughly misconceived notion in law. We have already taken a view which has been upheld by Supreme Court. We are ready to assign reasons right now. If that is your prayer, you said that I have been appointed guardian. To execute it wherever you can. We will, in this proceeding, we will not do it. Correct?
Yes.
Let's see what is the prayer. Just a minute. We are trying to look at the prayer sought in the petition and suddenly intervene. What's important? Deletion of his name, whether and the order to be passed in this case. What is important? We will delete it, right? No problem. What they file supposing if it appears in the list, what happens? The client will file a complaint against you in the bar council. That's why it is so important to delete his name. I want to know what is it. That if the name continues, he will make a complaint that I had engaged him, he didn't appear. So it's a professional misconduct, something like that. Right? Oh, that's repatriate. Same thing. All right, so
That is fine. Detailed reminder to the.
Of course. So you want only 2 weeks or 3 weeks? 2 weeks, why? Are they brothers? What's your name? Mr. Samar M. Raju, learned counsel for the petitioner, based on are their presence in compliance of the order dated 20th/6/2023, respondent number 6, along with the daughter of the parties, namely Kumari Vindhya, is present before this court. Learned counsel for the appellant learned counsel for the petitioner submitted that petitioner has come from US to meet his daughter, and he be allowed to spend 2 hours time with the child today, with his daughter today. The aforesaid line below, the aforesaid submission has not been fairly disputed by learned senior counsel for respondent number 6. She has submitted that respondent number 6 is ready and willing to permit the child to spend time with the petitioner under supervision of some family member. Who will remain present? At least you tell us that. All right. In view of aforesaid, petitioner is permitted to spend 2 hours time with his daughter, namely Kumari Vindhya, in the supervision of father of respondent number 6. Paragraph. Learned counsel for the petitioner prays for and is granted 2 weeks time to enable him to file rejoinder to the statement of objections filed on. Yes. His name be deleted. Yes. Huh? Who detain you? So who has filed this petition? Right. Chand, direct response. Produce the petitioner husband. No, whose husband? Want to know whose husband? See, first page. Petitioner prays that this may be pleased to issue writ of a direct respond to produce the. So this is Naveed Khan. Naveed Khan is Naveed Khan. Friend. But whose husband? Up to page 1 of the petition. Bottom synopsis. Petitioner husband by name Prashant Kumar. So that's why we asked you whose husband. Petitioner is Naveed Khan, definitely not his husband. So then it is written like petitioner husband. See synopsis. Bottom, page 1. Petitioner husband. Friend of petitioner. Some mistake. So this Aslam Abdul Razak is the detainee. Where is he? When? None for the petitioner, none for petitioner, Mr. Learned SPP 1. This petition has been filed seeking a writ of habeas corpus for production of friend of the petitioner, namely Aslam Abdul Razak. Paragraph. Learned SPP on instruction submit that the aforesaid that Mr. Aslam Abdul Razak's statement was recorded on in crime number 100 of 2023 for office 1623. What is this crime number? Acha. Was recorded in crime number so and so. That is the case registered pursuant to a missing complaint made on behalf of the petitioner. To stop, the statement of the aforesaid statement has been recorded on 1/6/2023, and thereafter he is set at liberty. Paragraph. In view of aforesaid submission, it is evident that the detainee is not under detention. Therefore, nothing survives for adjudication in this petition. Same in this court. Yes, sir.
Not illegal detention. It's not that.
You have filed statement of objection. Who is in your custody? Son of the petitioner. What is his age?
How this is. 2.5 minutes.
Where from have you got custody of his son? You will have to, being a father, you will have to see this thing, habeas corpus.
Illegal detention. Because parents has to be considered a lot. Without any consent of.
But you are facing a case of dowry death. Dowry death 302B. What happened? You are in jail. You are on bail. Yeah?
Very death note itself is not considering. There was no allegation. He placed my contention.
File it.
My contention is that.
You better file a rejoinder. You really want to prosecute it, right? In view of statement of objections filed on behalf of respondents. Learned Counsel for the petition phase 1 is granted. How much time? Weeks time to enable him to file a rejoinder. 18th, 19th, based on 19 July 20.
What I have.
19 description. Yeah. 22 Mela. Here. Here is mentioned as 22. Date of that they have.
This is not an order passed by us. This is Liverpool Family Court.
Yes,
Subject.
is the subject.
It mentioned the date.
Huh.
Not corresponding to the date.
Fine.
Yes. After the.
We can offer.
Huh? let the appeal be listed for orders on admission on Friday. 14. 14.
After 2 weeks time. Yeah, I repeat, I mean, don't look at pipeline in that.
We will fix the date. Tell us what is this 2014 matter. Whatever it is, what we are only telling you that appeal of 2014, 9 years it's pending. Whatever you do, whatever you want to do, tell us a date on which we can hear it.
Yeah. After nothing, today not. Mark paper and find it. I went to the office. Yeah, refused to do. There is the office, they want. They are refused to give. They were refused of the NPR. They told they were not. They cannot do it. Then the body gave it. Other than I have argued anywhere.
No, but how can you, Mr. Object to allowing an application for early hearing? We are not saying anything, right? He has filed an application for early hearing. Then that's what we are practically doing. That you are saying 3 weeks time for why this application should be deferred for 3 weeks. We will pass an order today. By way of courtesy, we asked how much time do you need and tell us a date. Instead of telling it, you are saying everything else. By way of a courtesy, we asked you, please tell us the date on which it can be taken up for final hearing. 23rd, 27th. Yes. Heard on IA 1 of 23, taking into account the fact that the appeal is pending before this court since 2014, IA is allowed. Let the appeal be listed for final hearing on 27th July 23. What recall dismissed. 2015 appeal, you don't appear. What to do? Where it is up. Taken upon that day, you don't appear. Otherwise, remain present on every day when it is not reached. What is this?
Didn't appear when it mattered.
Okay.
You didn't appear when it mattered most.
This 2015 appeal, Mr. You argue it next week. Reasons assigned in IA 1 of 23 duly supported by an affidavit order dated 9/2/2023 is recalled in the result MFA 6684 part 1. It is to file. Let the appeal be listed for final hearing in the next week.
22. Mohan K. Please, Kulkar sir.
See, non-compliance. Let office objection be complied with, none for applicant mark their presence learned counsel for respondent 1 and 2. Let office objection on IA 1 of 22 be complied with within 1 week list thereafter.
Yes, Adi Party.
There are 3 times to,
Want to file objections to IA?
I have a witness application. I have to file a case.
Why 3 weeks? Current counsel for the appellant praise fund is granted 3 weeks time to enable him to file objections to IA 1 of 20.
Sri Mallayagowda AP,
Requirement of filing the complete copy of statement of objection when verifying statement is dispensed with in the result IA 1 of 23 parties. Second, mark his presence for, you are appearing for which respondent?
Before it. 600. Before 600.
3, 4, 6, and 8. What do you say? You have been served with the notice of condonation delay. When is the government stated IA 1 of 20 on reasons assigned duly supported delay of 82 days in filing appeal is number IA. Let the appeal be listed for orders on admission.
Number 25. The Commissioner of Justice. The author are regular.
The delay of 17 days. What is RP presence or you have to file objections. How much time? Heard on IA 1 of 22 reasons for some delay control. IA is allowed. Permit counsel corresponding based on this granted 2 weeks time to enable him to file objection to IA 2 of 20. List there are.
Number 26. The bar.
Yes, Mr. Shastri, you can't oppose condonation or delay filed by the state. Heard on IA 1 of 2022 reasons assigned to delay of 122 days in filing the appeal. But 28 days. IA is allowed. You want to file objections? How much time? Hearing on admission. Right. Let the appeal be listed for orders on admission and consideration of IA 2 of 22 in the next week. What do you say? Condonation 17 days. Delay condoned IA is allowed. It is set for orders on admission next week.
28.
For the appeal.
28. The amendment. The minority.
Well, early hearing who has filed? Want appeal to be heard early. Why? You are appearing for the wife. Why? Marriage is resolved by decree of divorce. Well, what is the hurry? Maintenance.
Additional document.
You filed objections to it? No. Huh? You can take up the IA for maintenance, correct? Let him file next week. We will let the appeal be listed. When do you want? Let the appeal be listed for consideration of IA 3 of 2022 on 18, 19, what date? 19. Later date. Distinct. He knows that. See how you write.
29.
Yes.
It doesn't.
Yes.
ये पूरी प्रॉपर्टी है
हाँ.
ये फाइल for seeking direction to admit the child, child is already admitted to disclose the name of school. ISC responded to to pay the full fee. So these applications are
Yes, six is what I
six applications filed by the respondent to pay the school fee. Now, your lordship may kindly, there is the order dated on IA number 3, wherein is already accounted. In the next academic year, I am ready to pay the fee. Let him, if he has already admitted, let him for this particular, I will pay the fee. IF6.
which school?
IF5, you only disclose the name. If you have-
This school. Which school? Student.
Yes, sir. He has been admitted in school and I'm yet to receive the details.
Which school?
There are 5 schools that have been shortlisted and she has already been admitted and she's going to school.
For the mother, right? Don't know the name of the school.
No, actually, we have tried to contact my respondent, able to get details. And moreover, my lord, in IA number 3, that has been filed in the year 2000.
No, so next year he's ready to pay. He's not contesting, right? He wants,
He has to pay for previous year also, my lord, as per the order of the farm report.
he's ready to pay. If you have to tell the name of the school to him, he is the father. But what is this
Second one
about? Yes.
Passing this order, my lord, he has gone to the school wherein child was admitted in the previous year and he has created a nuisance to that extent.
Therefore, you will not tell us the name.
No, if at all he has taken undertaking that he will not create any nuisance, my lord, because he has got as the principal when it's graduation day, I'm supposed to know all those details. And if there is no graduation day in the school, how can the school authorities change their rules? And he has lodged a complaint before the head office also with respect to the school, my lord, stating that the principal is not giving enough room and he is not getting enough information regarding to graduation day and all.
You are deliberately withholding the name of the school. You are deliberately withholding the name.
No, my lord. With it, give me 2 days or weeks time, I'll get a name as well. I'll file an appeal to that extent. There is no doubt about it. Question is, my lord, when they have admitted that they are supposed to pay the school fee of 88,000 for the previous system, and he has not paid.
He will pay. There is no doubt he is agreeing for that. You tell him
Pay from this academic year.
whatever is the order. What there is already an order, right?
So not I-
So as per the order, he will pay.
It's saying to say that he will pay for the academic year to 2022. The order has been passed for the academic.
No, if he says appeal is allowed. No, if he says appeal is allowed, so will it carry? So we have, who will say that what date he has to pay? The court has to say. Let him say he will not pay anything or he will not do anything. Let him say
Only
what he will not pay. So that IA is you have filed. No? So he will decide the IA. Then who will decide? No, who will decide? Then how is it his consent material? What did we ask you? Simple question, right?
in a week, I'll discuss it. Including dates and if possible, we'll produce a document also. Where child has been.
Your statement is sufficient. Why document? We are not.
In a week,
In these days of communication, sir, for disclosing a name of school where the child has been admitted, you need a week's time. Even if she is living in some European country, within 60 seconds, you can get which school in Toronto your daughter is admitted if she is there. What is the big? She's in Bangalore, right? Why she needs to come to the office? We are asking you to disclose the name of the school that you can tell us. Why she needs to come to? I really don't.
Since last 3 hearing dates, he has been insisting for the name of the school to be disclosed. And you are aware. Only thing is you are not disclosing.
Last date 22/6/2013, you are present, right? Because he did not appear, case was adjourned. You knew it, that all he wants is, and he is entitled to know. That's a different thing that we can put him to terms that he should not create nuisance and all that. That's a different thing. But how can you say that I will not share the school's name even with his father? How?
This time I'll file.
You are not running a proprietary concern, right? Of bringing up your daughter or son, whosoever she is. Huh? What is it?
And then the name will be.
It is a pity that for such small things he has to file IA. What is this? Contest these matrimonial matters with an element of human touch.
The settlement talks are going on. Settlement talks are going on.
But despite that, you will not tell. So fine, learn it. So we will ask her to personally remain present. Will she remain present, or we should issue a bailable warrant? Huh? Bailable warrant? What? If she is not listening to you, then we will issue a bailable warrant. No, because you are not answering straight things, right?
Yeah.
No, all right. We understand that. So, Mr. When will you execute the bailable warrant? She stays here where?
No, I think.
Are you instructed not to disclose the name of the school?
Kalasi Palyam. Here only. Get her tomorrow. He is unable to contact her because death in the family. So you get her.
He's not saying in last point.
Wherever. It's the job of the police.
Again,
Additional government advocate will find out whereabouts.
Are you instructed not to disclose the name of the school? If that is instruction, you can reveal it to the court. I have no instruction.
Always, Mr. You are an officer of the court. Always remember this in mind. You owe a duty to be fair to the court. What we are asking, you could have said, sir, this is the name of this or whatever, or tomorrow I will disclose the name, provided he is not. Please ask him not to create nuisance. That is understandable. But for such a petty matter, we are wasting 5 minutes time, and the proceedings have reached to a stage where we are required to issue bailable warrant despite the fact that she has engaged you and paying you fee. Why do you want her to come? We have crossed this thing. We understand, right? Why do you want her to come to your office and to pay value, to give you instructions, and as well as the name of the school? That's why you want her to come to the office. Don't we understand? All of us, my lord and we have practiced there I have practiced there till 2008. My lord has till his elevation. All these lyrics we understand. So you are not prepared to disclose the name. So we will direct personal appearance. Right. Mark the presence. Learned counsel for respondent number 1. Respondent states is unable to disclose the name of the school in which the child has been admitted. He further submits that he has no instructions to disclose the name of the school where the child means daughter has been admitted. In view of aforesaid, we are left with no option but to issue bailable warrant to secure the presence of respondent before this court. Let a bailable warrant in the sum of ₹10,000 be issued to secure the presence of the respondent before this court on 17th of July. You do it, Mr. Bailable warrant.
You are relieved of your obligations. Don't worry.
Don't worry now. Nothing, no death, no death, nothing. You don't know anything. You tell, you did not tell me. The court has done it. Stop.
I am able to get the name of particular school where it's been admitted. Within a week, I'll file an affidavit stating that in which state child has been admitted.
What is the age of the child? So when the academic session in state of Karnataka is commenced, and we are which June? Date? What date? 1st June. Today is what date?
Like one.
So Despite 42 days, you do not know where the son, your daughter has been admitted.
So by this time, you should have told at least by 2:30 would disclose the name of the school. After having
We are directing the issuance of bailable warrant despite that you are arguing. That's what my lord said, right? This is the statement which we expected. That sir, please keep this matter at 2:30. I will inform the name of this. We are not asking you to file an affidavit. Are we? We are relying on you as a counsel, as an officer of the court. Who has asked you to file an affidavit? Or should we ask the police authorities to find out and submit a report? No, don't do it. You retire from the case. We will appoint an amicus. We will ask the police authorities where she has been admitted, and they will submit a report in seal cover, right? No instructions. So then, learned additional government advocate. In these circumstances, of course, additional government advocate is directed to ascertain in which school daughter of the petitioner has been admitted. Daughter of the petitioner, namely, what's her name?
Asmina
Zara has been admitted, and to submit a report to this court on or before next date of hearing. Based on available warrant direct. Date that fact. Based on what date? 17th you inform. You have to contact her only and find out where he is unable to do so. Right? You ask the police officer SHO to contact her and give a. Take the name of the respondent from the details. And her mobile number also must be given in Wakalatnama and something. Wakalat, it must be mentioned. See. Thank you. No, available warrant we have, because see, we have to only ascertain the name. He is refusing to tell us. He is saying that I will need 1 week's time and I will file affidavit. Nobody is asking him to file affidavit. Despite that, he is not ready. We don't need your assistance. Thank you. We don't need. This court is competent enough to decide. We do not want to perpetuate injustice because of your inefficiency. Therefore, we have directed them, police officer, to ascertain the name of this school, right? Otherwise, we could have passed an order to date. This is the level of assistance in a given case. We are sorry. What to do? Unfortunately. No, this story we don't want to hear third time. 5 names and all. It's all nonsense, right? She's not getting into admission into a postgraduate course in MBBS where she has to indicate her choices. This MS Ramaiah college, this college, orthopedics, radiology. Don't tell us MS general surgery, ENT. She doesn't know in counseling which seat she will be allotted. Don't tell us. 6-year-old child. Do you think that we lack practical wisdom? And you can get away with whatever you say in the court? No, this is a simple thing. You don't have to do anything now. It's their duty. He will face the music if he doesn't show the name of the decision. You be free. What is happy? Nothing. We are not asking you to do anything. This will find out now. They will give us in a report, right? Where this girl aged about 6 years has been admitted. Mother doesn't know which school she is. 5 schools.
No, do you think that you are convinced that your client has not instructed you regarding the name of the school? Then
I told her that I need to get the details of the same. Come that and password I'll get the.
Why do you do it? It's not that you are so dumb that you don't understand what we are trying to tell you. It's a simple thing. father wants to know the name of the school where the child has been admitted. Your apprehension is that he will create nuisance. You could have told us that please ensure, sir, my lord, that he doesn't create nuisance. I am ready to disclose the name. And please direct him to pay the school fee. That's the simple matter. This is going on for 15 minutes, and it's not that you don't understand. We are surprised. What time? Your client is not giving you instructions. That's why you are deliberately doing like this, so that she comes to your office. Then, did we ask you to file an affidavit? No. Did we ask you to file an affidavit? We only, what you could have done, you don't have our mobile number. Then why my lord said that you could have told us at 2:30 this is the school where she's admitted. Simple. Why do you do it? We don't understand.
Asking the name of the school to pay the fees.
And you should realize that he has said that I want to know the name of the school and I want to pay fee. For Mr. Delete everything. Praise for adjournment. Let's tomorrow. Tomorrow Tomorrow we will pass an order directing non-bailable warrant to be issued. You tell your client, right? This is not same matter coming repeatedly for. This is third time for these very IAs. Don't you think that we have something better? Simple thing, right? And if, as and when some complicated matter comes, we will engage you as amicus curiae. In that case, you argue the question of law, right? Not in this case. 5 schools and this thing. Don't.
See, without the order of the court, you should have disclosed the name to him. You would not have filed the application at all.
What is this? After all, the child is the victim in this battle, right? Please understand. That's why we always feel that these matrimonial matters should be dealt with by senior counsels or persons having sufficient testing experience at the bar. You are a young person, you want to generate litigation, everything. We are not asking you to file an affidavit, you want to file an affidavit. Don't you think we don't understand why do you want to file an affidavit? Huh? Why do you want her to attend your office? No, but we are not asking. Enough for the day. Tomorrow, then the remaining part. We have spent enough energy on the case. Thank you. Huh? 5 and 6. 5 and 6. How much time? It counsel for the applicant praise for the granted 3 days time to enable it to take steps for service of notice on respondent 2, 5 and 6.
May be connected with
List for
90 and 88.
as spread list for analogous hearing along with commercial
88 and 19.
88 and 90. Commercial appeal 88 and 90. Of 80. So good that you appear in commercial appeals also. Huh? All matters. No, good. No, you have appeared before me only in EPS corpus. That's why. Good to see. Yes. Yes. Issue notice of IA-1 of 23. 3 and 4 of 23 and 4 of 23 as well.
For respondents.
Yes. No delay. We'll condone, Mr.
Lord, delay can be condoned. Stay may not be given. If your lordship is inclined to give the stay, I want to address the court with 2 sentences.
Yes, of course.
Lord.
On IA-1 of 20. Just 1 minute.
Please.
On IA-1 of 23 reasons assigned duly supported delay of 45 days in filing the appeal is condoned in the result IA-1 of 23 is allowed. What stay?
My lord.
What? Yes.
My lord. Trial
on
court has
IA-1.
waited for 2.5 years after the appellant filed her wakalat and objections, waited for her to come and cross-examine and go through her evidence. She has not shown up. She has not filed any case for restitution of conjugal rights. Now she is going around with the relative saying, I'll get a stay. Stay means that I'm still married to him. I'll go file a complaint against my husband under 498A 3 and 4 of DP. Lord, let me draw your lordship's attention to two exhibits, only two of them, Exhibit P3 and Exhibit P5.
But nobody can prevent anyone from lodging FIR, right?
That is correct. That is the reason that they are seeking a stay. I'm already divorced. No, if I am divorced, 498A cannot be lodged against me because 498A is for against the husband. It is a.
In respect of past conduct, it can always be lodged. If
My
you
lord,
have
my lord,
committed it
my lord,
offense, we don't know.
498A is not attracted. If the moment the divorce is done, the moment divorce is done,
If something has happened before the divorce is granted.
For that,
nothing has happened. Now she is going around.
hey, we don't know. We don't know. We don't want to certify.
My lord,
We
that
have
is
not.
true. That is true. If something else has happened other than cruelty, she has the right to go file a complaint. Now,
You file objection, Mr. But instead of only arguing, you file objection to this IA. That is
please,
understandable.
my lord, till then, don't give me 2 days time. I'll file objections. The stay means she is going around saying.
No, we don't. That is your version.
Sir.
In the absence of any, that is your. Please file objection. We will hear you.
Please,
on Monday, right?
Please, my lord, let me just draw your lordship's attention for two exhibits, my lord, for 1 second.
Current counsel for respondent.
Exhibit.
You are granted time to file objection. Why? Please argue on Monday. We will hear you. Current counsel for respondent is granted 2 days time to enable him to file objections to IA 2 of 23. Let the appeal be listed for consideration of IA 2 of 23 on Monday. 17.
Much obliged.
December 33. Consideration.
Yes.
Why this appeal is listed? Why this appeal is listed? Who is the Congress? For appearing for whom?
You are appearing for whom?
Appeal is listed for what purpose? No.
Have you gone through the cause list?
He doesn't have. Then why do you need an adjournment? Nothing. Heard on the question of admission, appeal is admitted for you. This is a statutory appeal. It lies as a matter of course. You are a respondent. Why should you seek adjournment? What does it, Mr. Under which provision this appeal has been filed? Give him. No. Please see. You don't have the file. File also, book also, act also. Please read. We have plenty of time. Please read. Which provision? Hey, memo of appeal give him. How will he know? Which provision the appeal is filed? Huh?
19 of what? 19 of what? Who has filed the appeal?
So what does section 19 say? Read.
Read, you have to read.
So appeal shall lie. So can we dismiss it saying that doesn't lie? So it has to be admitted and heard. So what for you are seeking adjournment? Is seeking passover. beyond comprehension, right? Nobody is asking you to argue. So if we ask you to argue, then you should say my senior is unwell. I cannot be put any question. I don't know anything about the case. I don't have file. I have right to not to know the case, about the case. That all is understandable. But we are not asking you to argue. What does law say? Appeal shall lie. Has to be admitted. We don't know why he is seeking adjournment. Counsel for appellant pass over. What for? He is admitted for hearing. The record is there. Let the same be listed for consideration of pending IA the next week. Happy? Huh? Next week. Yes, Mr. Nayak.
What protects the thing?
Ah,
Right from the.
Appellant file is dead. I reported the matter there on 5/4/2023. Your lordship has recorded. They are not brought the LR on record.
Which matter, madam? Which matter?
34.
That's why it's that the thing I will admit it was filed. Now, there is a office no.
substitution of LRs of disease appellant number 5. And-
Appellant
No,
file
file.
is not dead. Appellant file is dead, not brought record. Your
I'm on office no. There is a office no that I have not complied the order.
Yeah.
I am giving explanation that
File.
no, it is not filed. The reason is I tried from the expedition record that is destroyed. Then I told the party to get it from the land revenue record. 20 years old, they are unable to do it. For 4 weeks time, you are not available. So it will be available with the respondent. They are the holder of the award.
Madam, you are aware about LRs of appellant number 5?
I reported before this honorable court. Your answer kindly see the article taken.
It is that
5/4/2023.
Yeah, particulars of LRs.
Madam, you are having the particulars of LRs of appellant number 5.
Then appellant file is dead. They are to bring. I don't know who they
You have
are.
the particulars. You have the particulars.
When it
I
counsel
have
for
no
the
letter.
appellant,
His wife and children are
case
dead.
warrant is granted 3 weeks
Appellant file is
before
dead. This is their duty.
an application seeking substitution of LRs of appellant. Next week. Chief is South Carolina Council. You are Mr. Muralidhar Peshwa, Learned Counsel for Respondent, prays for adjournment to enable him to seek instructions and to argue the matter. Yes, next week.
Connected thing to do with the person.
7.
The submission is made by the respondent company last year. The FR number.
Mr. Good that you appeared in this case. My impugned order application under order 1 rule 10 has been rejected. That's what we were wondering that today there were so many cases where we.
I use also that.
Why so? Please commercial code. Yes, yes. Huh? Yes, of course. Mr. Ravi Shankar, tell us whether if commercial court rejects an application under order 1 rule 10, an appeal would lie under 13(1)(a). Our impression, we have held like it doesn't lie. Please. Please see. 13(1)(a). Read, Mr. Judgment or order. Provided that, no, provided.
Otherwise,
Under order 43. So order rejecting an application under order 10, 1 rule 10 is not an order applicable under order 43. That's the what you will have to challenge it in a writ petition, maybe, right? Correct. We have been taking this with. You are always ahead of times. See, 39, in 38, we are 37, we are deciding this question. Correct. Correct, Mr. Vikram Mudigas. That's what we have been taking a view like this. That's why we thought that both of you are available, so we should. No, we were just wondering whether, learned counsels are not reading this provision 1A or we are interpreting it. This was the, no, Mr. We are telling you, Mr. Ravi Shankar, this was the discussion when we came from to the court. This was the discussion we had, both of us, that are we correct in interpreting 13(1)(a) proviso, or senior counsels or counsels are not reading it. So that's why we took this opportunity to. So it's correct, right? This appeal. Correct.
But if this hospital the restriction, if it goes to that, the appeals can be made, provided it's available, the user goes to our party. This is a restricted one.
Yeah. Correct.
Because now we are.
All right.
I don't want a situation, I can remember there are a single.
Yeah. Each day, no appeal is maintained. So what happens? This is the additional city civil and session judge.
So then money happens.
Counsel, senior counsel for the appeal. Third on the question of admission. This appeal under section 13 in bracket 1A of the Commercial Courts Act 2015 has been filed against an order dated 6th of December 2021. Passed by the commercial court, by which application preferred by the appellant under order 1 rule 10 of the Code of Civil Procedure has been rejected. Paragraph. We have heard learned senior counsel for the appellant on the maintainability of this appeal. Paragraph. Section 13(1)(a) of the Commercial Courts Act 2015 reads as under. Right. Thus, line below, if subsection 1A is read in conjunction with the proviso, it is evident that order rejecting the application under order 1 rule 10 of the Code of Civil Procedure is not an order appealable under order 43 of the Code of Civil Procedure. Therefore, in the considered opinion of this court, appeal under section 13A does not lie. Paragraph. The appeal is therefore, the office is directed to return the certified copy to learned counsel on subscription thereof by a photocopy. Line below, accordingly, the appeal is disposed of with the liberty to the appellant to take recourse to such remedy as may be available to him. Yes, sir. One minute. 39, same order.
Connected matters to the
37.1. Adjournment. What office objection? What is your submission? Then. So, how can you implead anyone who is not a party on your own? In view of office objection, learned 37.1, learned counsel for the appellant pays for short accommodation to enable him to move an appropriate application. Next week, this all by public money, correct? Law does not apply. Order 43, what happens? Please, Mr. No, not 73A. This appeal is barred by limitation. Please, study the case properly to assist the court. You are just like, you are taking all sorts of liberties because National Highway of Authority of India, right? National Highway of Authority, therefore all sorts of liberties, right? We should overlook law. You will implead anyone on this also should be overlooked. Delay is there, that also should be overlooked. Merely because it's public money, therefore stay. Let your office be attached. What will happen? Nothing happens. What is an order of attachment? Only a piece of paper posted, fixed on your office wall. Nothing happens. It will not be closed. Sure. Also, then what is the explanation? It takes other hand. You first file. We will, whenever you want to tell us, when will you file? List in the next. What can be done? You tell us the reasons for condonation of delay and whether this court has power to grant stay until this delay is done. What is the explanation for condonation of delay, whether without issuing notice to respondent ex parte delay can be condoned? Please tell us. Saying very easy, right? Grant stay, do something. We are bound by law, right? What is, have you read 43, order 43, 41, rule 3A? Give CPC 2.
What were you doing?
Ask
No, what were you doing since March? It is filed in 14th March. It's filed on 14th March. What were you doing since then? You are aware that the order of attachment would be issued in case the amount is not deposited. You did not move the court. You did not remove the office objections.
Did you understand the query? What is the query by my lord? 14th March 23, you filed the appeal. What did you do till today for 3 months? What did you do?
So lapse is not on the part of the court. Lapse is not on the part of the decree holder who is trying to execute the award. Lapse is on the part of NHIA. Why should there be indulgence for the lapse of NHIA? That too in contravention of law.
Next. Okay. Keep the books handy, right? See, that's you should thank him. Huh? Otherwise, you were not bothered. You were not reminded that proceedings are fixed for tomorrow. He got right. Yes. We'll admit it. Stay. There is a decree separately, right? Sure. Instructions or how much will you pay? Then we'll let him file objection. It is admitted for hearing. Office is directed to check of the record of the commercial code. Let objections, if any, to IA 1 or 20 be filed within 1 week. Within 1 week, list thereafter. Ah, all right. Yeah. Yeah. Ah.
All category.
Right. The proviso would cover a case. So see, Mr. He has improvised between 37 and 39. Huh? You must be cautious. We're opposing Mr. Ravi Shankar. Lighter weight, all this needed is by way of compliment to him. Yes. So same order. Only thing is order dated, same order, right? Vikram heard on Counsel, heard him also, heard learned counsel for the parties on the question of maintainability of the appeal. And then this appeal has been filed against an order dated 3/7/13/1A. Everything will be same, right? 3/7/2023, by which application preferred by the appellant under order 1 and order 11 rule 1 has been rejected. Then rest everything else would be fine. Same, right? 32.
One is. Papers are.
We thought that you are saying that I will not do it for 1 week.
You want to produce some documents in this year.
You can't say anything. All of this is the order.
How did you?
Acha, 35 interim order granted on, yes, interim order granted on earlier application. Yeah, right.
Santosh Kumar TN.
Myself, Santosh Kumar TN, sir. My lord.
Santosh Kumar, this is public interest litigation. Office has told us it has to go before Honorable the Chief Justice, right? You have said that you are a public spirited individual, correct? In para 1 of your petition. So this is in the nature of a PIL.
Okay, my lord. Because my interest.
Party, correct, party in person, mark the presence, party in person appeared through video conferencing. Paragraph from the governments made in the writ petition, we find that the petition appears to be in the nature of a public interest litigation. Therefore, let the same be listed before a bench headed by Honorable the Chief Justice. On which date?
Tomorrow.
Next week.
Okay, my lord.
Not tomorrow. Next week, Monday.
Yes, my lord.
Monday.
Yes, my lord.
17 July 23 is possible. Yes. It didn't appear. Why? What? Yes. She is fine. You said not fine. What did you find? What did you find? Correct, right? Why? So have you filed an affidavit is ready? Affidavit. Affidavit as.
See, you have not filed affidavit in terms of the law laid down in Rajesh versus Neha's case. For this reason, you filed affidavit.
It counsel for the appellant submits that on account of circumstances beyond the control of the appellant, the appellant could not file the affidavit as required to be filed in view of law laid down in Rajneesh versus Neha, AIR 2021 ST 569. Further submitted that along with the application for recall, an affidavit pertaining to statement of assets and liabilities has filed. Paragraph of the aforementioned reasons, judgment dated 26/9/2022, dismissing the appeal for want of prosecution is default. The result MFA number 8262/2015 is restored to file. Accordingly, IA is allowed. Right? She has filed an affidavit along with the application for recall. So we have restored the appeal.
Serial number 5 was taken, junior, start first.
Let office objections be complied with. Let steps for service of notice on disease respondent number 2A be taken within a further period of 2 weeks, failing which this board shall direct deletion of name of respondent number 2A at the risk and cost of the petition. At the risk of the settle. Settle.
ಸರಿಯಾಗಿಲ್ಲ ಮುಂದೋಗಿದೆ.
Of the appellant, even when the matter is called in second round, it appears. Let awaiting appearance of learned counsel for the appellant hearing this effort is like.
Last time one advocate submitted that party is not agreeing. Then I mean. Last time one advocate submitted that he is not agreeing for settlement.
See order sheet.
Last time one party.
Is it there?
Time it was.
Right.
Bill is quite challenging. Judgment and decree dated 1st February 2014, passed in MC number 79 of 2011 of Family Court at Bangalore. Such judgment and decree. Item, allowed the petition filed under section 13(1)(1)A and 1B of Hindu Marriage Act of 1955 and the marriage dated 16/10/2003. For instance of the for the petition seeking dissolution of marriage. Next. Agreed by the aforementioned judgment and decree by us at the instant. Request of the request of the parties, the matter was referred to the mediation center at Bangalore. Settlement. The mediator has some of agreement entered into the parties accordingly. Settlement arrived at the parties. The conditions of settlement as under page number 2. Up to setting terms of settlement. Modified in terms of the settlement referred to above. Accordingly, the appeal is discussed.
Yes.
Judgment
We accepted the settlement. In terms of settlement, the decree is modified.
is
Settlement matter for instance. So what happened to the main appeal? You are challenging which part of the judgment and decree? You are challenging which part of the decree? Your wife. You filed a petition seeking dissolution of marriage. Divorce was granted. How much compensation awarded? 10 lakhs. All right. He challenged the decree for divorce. Husband, what? No, 10 lakhs you are supposed to pay. 10 lakhs you are supposed to pay. How much he has paid? According to you? According to you, how much he has paid? Difference is 67,000. Difference is 67,000. What is your claim for enhancement? What is your evocation? Any children from the marriage? How many? Staying with you? What is it? What is he? He. Husband. What is he? Hotel business.
Here,
Now, according to his affidavit, what is his income? How much he has shown?
monthly expenditure, 6,000.
Income. What is the income he has shown? Your client has married again. Your client has married again. Appellant has married again.
But sorry, there's no income from any source.
No income. He owns any agricultural land or any other land, immovable property. Then it is grandmother's property. So it's grandmother's property, not his property. They are Christians. There is no question of acquiring right by birth. So it may not come to. So how much income he has shown? How much income he has declared? According to you, what is his income? Ram, according to you, what is his income? According to you, 30,000 per month. According to you, he's earning 30,000 per month. He owns hotel in which place? He's running hotel in which place? No, in which city? Which village? Which taluk? Taluk, Mangalore. So how long is running the hotel? 2020. All right. Earlier to that, what was he doing? Hotel business. Whether the petition is filed on behalf of the daughter seeking maintenance. How much is ordered? Whether the petition is filed on behalf of the daughter seeking maintenance. What happened to that? We are not asking about this case. Any other petition is filed either in the section. What is the expenditure you are incurring for the school and other expenses of the daughter?
Expenses.
Then I paid another 33,900. I got fees of 21,000.
What is monthly expense? Husband has no income. That's what he says. You have to maintain the husband. Now how are you sustaining your expenses? What are they? What is the extent of land held by his grandmother? All right. It belongs to the grandmother. Can it be taken as his property to assess the alimony? Can it be taken as his property to assess the alimony? You are asking the question. You want to know the law. Concept of joint family is not there. Where is the document to show that he is running hotel? Where is? How do you say that this belongs to him? Is it his phone number? Is it his phone number? What is page number 13? This page number 15. Statement of account. Whose statement of account? Sir? The page number 19. According to him, what is his avocation? According to him, in his affidavit. And you filed execution petition to execute the decree for maintenance alimony. You filed the execution petition to execute the decree for alimony. She's a village in Mangalore. Now, how far is that hotel from Mangalore city? Itself is 25. You accepted. Question. What is probably staying with his mother? Hence the amount he can award interest. In that case, awarded without interest. Since he says he has paid 2,87,000, just to 20. Balance amount he has to pay interest from this. Yeah. Balance amount interest from this. Mother or grandmother? All right. All right. No, non-veg hotel will will lead more income. Our thinking was otherwise. This cross objection is filed. Noting. From family court. Invoking section 91 of Family Court Act of 1984, read with Order 41, Rule 22 of Code of Civil Procedure 1908. The wife has filed the present cross objection being agreed by rejection of part of a government alimony, wherein she has sought permanent alimony of rupees 25 lakhs. You sought 25 lakhs. 25 lakhs in terms of the impugned judgment and decree passed by the family court. Rupees 10 lakh is awarded towards permanent alimony. His wife is in respect of this cross-objection is in respect of disallowed. The same judgment and decree, the petition filed by the wife seeking dissolution of marriage on the ground of cruelty and desertion. Which ground you invoke for seeking dissolution? Petition filed by the wife under section 10(1), Roman 10, Roman 9, Roman 10, read with section 37, 41 of the Divorce Act is allowed to stop. Agreed by the decree for divorce, the husband had filed appeal. MFA? Yes, yes. MFA number so and so. 7/30 of 2016. Same is dismissed for non-prosecution wide order dated. Hence, this court is only confined to ascertain, to decide the quantum of alimony payable to the wife. The facts necessary for adjudication of the case can be summarized as marriage was solemnized on 16/1/2010. The marriage is consummated, and the marriage, the couple have a daughter, was born on, when the daughter was born, foot. Thereafter, it appears that the relationship between the husband and wife strained, and accordingly, the wife filed a petition seeking dissolution of marriage and also permanent alimony, making allegations against the husband. It sought dissolution of marriage on the ground of cruelty and desertion. The family court after trial has accepted the contention of the wife and granted a decree for dissolution of marriage, and also awarded rupees 10 lakhs as permanent alimony. As already noticed, the appeal filed by the husband challenging the decree for dissolution of marriage is dismissed for non-prosecution, and the wife is prosecuting this cross-objection seeking enhancement of permanent alimony. In terms of the law laid down by the Honorable Apex Court in the case of Dinesh versus Neha, the parties were directed to file affidavit. There was a direction to file the affidavit. Yes, the parties were directed to file statement of assets and liabilities by order dated 22/5/2023. Pursuant to the direction 19. Pursuant to the direction, the wife has filed the affidavit statement of asset and liability in the form of affidavit on 16/5/2023, and husband has filed affidavit statement of asset and liability in the form of affidavit on 7/6/2020. 7/6/2020. For the learned counsel appearing for the process of their wife. So the learned counsel would submit that the wife is not having any income. 10 lakh rupees awarded by the family court is inadequate, considering the fact that the wife has to take care of the minor daughter who is now aged 11 years. Now the daughter is age is 11. What is the age of the daughter now? 12 years. 12 years. It's also her contention that the husband is running a hotel, and his grandmother owns more than 5 acres of land in Wadi village, Taluk Bantwad, full stop. It is also a contention that the husband has not disclosed his real income and he has not disclosed his statement of account for the past 3 years prior to the filing of the affidavit. Thus, such he has not complied with the direction issued by the Honorable Apex Court in the case of Rajneesh versus Supra. Stop. This court has produced the records and also the statement of assets and liabilities filed by the wife as well as the husband. Stop. Documents placed before the court would establish the fact that the husband is running a hotel. Which village, madam? Hotel in? Which village? Wadi. Beverly village, Taluk Bantwad. And this is also an admitted fact that the owner of the couple is residing with the wife and the wife is taking care of the daughter. The wife has also produced the fee receipts of her daughter's school where she is incurring school fees of rupees 39,600 yearly. Yearly school fees of rupees 39,600. In addition to that, the wife has also produced the receipts relating to the medical expenses incurred by the wife. She has also produced the statement of bank account jointly held in the name of wife as well as her mother. You have produced statement for how many years? 3 years. Statement of account for 3 years. Husband has produced the statement of bank account. Husband has produced only for 1 year. Page number. Let's produce the statement of bank account held by him for a period of only 1 year. Stop. What can you make out from the statement of account? In a proceeding like this, the husband is the parties to the proceedings are expected to file the statement of account for a period of 3 years prior to the filing of the affidavit, and same is not. Is there a in this judgment? Does it say that the asset and liability statement or the statement of account has to be furnished for past 3 years?
3 years.
That's what we are asking. Which paragraph of the judgment? See, it's expected to ascertain the real income. Proceeding like this, to ascertain the real income and expenditure of the parties to the proceeding, it is expected that the party should file a statement of accounts at least for a period of 3 years prior to the filing of the affidavit. However, it is not forthcoming from the. However, the husband has not filed the statement of account for 3 years prior to the filing of the affidavit. Under these circumstances, this court has to draw adverse inference against the husband, and he is trying to hide his real income with an intention to avoid payment of alimony to his wife and the daughter. Next part. It's also forthcoming from the record that grandmother of the husband is owning more than 5 acres of agriculture land. Story since the parties are gone by the, since the parties are Christians, cannot be said that the husband is having a right over the properties, but the court can certainly infer that the husband is also staying with his grandmother and having some benefit from the income derived from the properties referred to in the said affidavit. It's also to be noticed that the husband in his statement of assets and liabilities has gone to the extent of saying that he has no income. This contention cannot be accepted. The wife has produced the document relating to the husband is an able-bodied person, and there is statutory obligation to maintain his wife and the daughter. In addition to that, the wife has filed a statement of asset and liability, indicating that the husband is running a hotel, and this aspect is not denied by filing the affidavit. Under these circumstances, this court is of the view that husband must be having an income of at least rupees 20,000 per month from his hotel business, and that being the position, he has to spend at least 10,000 per month towards the maintenance of his wife and the daughter. Next paragraph. This court has also noticed that the family court has awarded rupees 10 lakh permanent alimony to the wife, and it is stated that rupees 2,20,000 is paid by the husband in an execution proceeding filed before the executing court. So the husband has, however, the husband has made a statement that he has paid rupees 2,87,000. At this juncture, this court is not in a position to decide as to how much amount is paid by the husband. However, since the matter is pending before the executing court will decide as to the arrears payable by the husband. This court has also noticed that while awarding rupees 10 lakh per annum, 10 lakh as the permit alimony, the family court has not awarded any interest on the said amount. Taking into consideration the materials placed before this court and the asset and liability statement filed by the respective parties, this court is of the view that the permanent alimony is to be enhanced by another 5 lakhs. And in addition to that, the appellant should be made liable to pay the taking into consideration the husband has not yet paid the alimony awarded by the family court, and also the wife is made to file a petition to recover the alimony. This court deems it appropriate to award interest on the alimony awarded by the family court. For the aforementioned reasons, we are of the opinion that the husband should be made liable to pay 6% interest on the amount of alimony awarded by the family court from the date of the judgment till the date of payment, and alimony is enhanced by this court by another 5 lakhs rupees. And in all, the husband shall pay rupees 15 lakhs towards permanent alimony, along with interest at the rate of 6% per annum from the date of the judgment. %, on the amount of rupees 10 lakhs awarded by the family court. Accordingly, the execution judgment and decree is modified as indicated above. Appeal is allowed in part.
Been filed by wife. Give it to her so that she can. You could have given it to her, right? She's sitting here. What do you do? What's your? Friend tell him. This food for affidavit. Affidavit has been filed. Mr. Affidavit has been filed by you, right? Why do you want to? Forget about.
What is your avocation? What is your income?
Designation, Mr. Designation. 812. How many children from there? What's your offer? What's your offer?
But this offer was not both. I mean, this is the third round of it. Again,
You better. It's better to settle it as soon as possible. And live in peace. Live in peace, which is most important in life, right? We hope that
both are still not done.
is your expectation, madam. Tell us a figure. Just tentatively, we are just asking. It's not that we will hold. Did he pay amount of maintenance to you earlier? You correct. Our patients. Yes. When this order was passed, when 10,000 order directing 10,000, when it was passed. What's your age? Age?
Ideally speaking, in a matter like this, when you get instructions that you are only interested in alimony, you should immediately communicate to your counterpart and get it resolved.
All right, so how shall we take it? Yes, madam, day after.
Bear in mind, 10 lakhs is the years.
No, first of all, you tell us what you are willing to pay, then we will adjudicate. Remaining. Why should you address her? You address the court, right? Why should you address her? Yes. Fine, fine. You please tell us. Whether we are here to adjudicate, we will adjudicate. What should be the quantum? We want to know how much you are willing to pay. We will. It's everything is there. We are not deciding anything. Fine. We will hear you. When do you want? Day after. Learned counsel parties. Only pray for short accommodation to enable them to seek instructions. List 14 July 2023.
I have filed a memo of retirement, my lord, at my learned. I have filed a memo of retirement. And Mrs. Sona Vakund is appearing, my lord, my place.
Ah, yes, she's here.
Seeking adjournment.
How much time, madam? We have to practice 10 days time. People are to seek instructions and to argue. This after 10 days.
I may be permitted to retire.
Ah. Fine. It's permitted to retire from the case. Office is directed to delete his name. Yes.
Grateful.
Huh? First time. He has to seek instructions before arguing. Correct? Obviously. Yeah. Seek instructions. Argue the matter this next week.
$46. Just clear. In okay.
My lord, 46.
Oh.
My lord, I represent the appellant in this, my lord. The appellant has made several allegations against me, my lord. That being the reason, I will be retiring from this case, my lord. Matter may be urgent. I'll file my retirement memo, my lord.
You have informed him?
I appear for the
No.
Why-
Have you informed
I have
the appellant
already
that you are?
informed, my lord. I have to send the notice, my lord. Retirement notice. That's the reason I'm seeking for an adjournment.
How much time you require?
A week's time, my lord.
Madam, your name, madam?
Champu Kavya.
It comes for the appellant prays for adjournment to enable her to file a memo seeking leave of this court to retire from the case. List after 1 week.
Much obliged, my lord.
The first lady. The Gayatri Rangaswamy.
We continue. Reading. Which case advocates are available? Which case? Huh?
Allah present.
We are talking 48. Which case copies are available? Not, we have not invited you to see. Huh? 68.
68.
What do you want? Adjournment?
No. Both parties are.
Then settle. Where is memo of settlement? 68. There are two more things, right? 1 minute. 68 we are taking. What it has been settled? Yes. You file, we will take it up after 2:30. Please file. Mention at 2:30, we will take it up. All right. Parties have come, no? We will take it up at 2:30. Please mention. Fifty-one. Ah. Appearing.
51, I appear for the second respondent.
Ah.
51, I appear for the second respondent, my lord.
Appear for the appellant. 51. Ah. Where is the? Next week.
2 weeks. Before this. That to recognize.
You are respondent, right? The appellant will withdraw.
Is
You are appellant. 51. Learned counsel for the appellant. Case one is granted 2 weeks time to enable him to report settlement. Yes.
May I permitted to make a mention, my lord?
What?
Please.
Yes. Why don't you, sir? She's here. Ah. Next week. Counsel for parties. Great counsel for the appellant. What you have to serve? Great counsel for the which connected matter? Which connected matter? She says connected appeal. Which appeal we will have? Which? That's what we are. She is saying connected matter. It's not there, madam. There is no connected case with item 49. Learned counsel for the appellant undertakes to supply a copy of memo of appeal, has supplied a copy of memo of appeal to learned counsel for respondent. Today, learned counsel for parties jointly pray for adjournment to enable them to explore the possibility of amicable settlement of dispute placed after 2 weeks. We'll come back 2:30. Yes. We will take up, you tell. Please tell him if he's available, records are available, we will take up. No problem.
My lord, serial number 54, my lord. My lord, I seek for a week's time, my lord, to secure the data for filing of the assets and liability affidavit. My lord. Your lordship has directed to file an assets and liability.
Before the order. Okay. Later half also. The court will assemble in second half also.
Please,
Not
please,
that-
please, please, apologies, sir.
Wait,
Please, my lord.
wait for a while.
Please, my lord.
Yes, ready? All right, yes, please give it. We will record. Yes. This appeal not the presence parties with their counsel present. This appeal is filed against judgment dated 5th of June 2020 passed in MC number 25 part 2020, by which petition filed by the respondent stroke husband seeking resolution of marriage under section 13 of Hindu Marriage Act has been allowed. Paragraph. Parties as well as learned counsel their counsel submit that the parties have amicably resolved the dispute between them. The term in this connection, our attention has been invited to a compromise petition which has been duly signed by the parties. The terms and conditions of the compromise read as under. Where it in pursuance of the aforesaid compromise, the respondent has handed over a demand draft for a sum of rupees 10 lakhs to the appellant, the receipt of which before us, the receipt of which the appellant acknowledges. Paragraph. In view of compromise arrived at between the parties, the appeal is disposed of. The marriage performed between the parties is between them. It is resolved by decree of divorce, and the appeal is disposed of in terms of compromise arrived at between them.
Be granted.
Decree, decree granted by the trial court for dissolution of marriage is confirmed. Instead of granted, you say confirmed. Which item, Mr.? This one. So appeals are disposed of. So you will have to say which appeal under section 13, which appeal under section 13, and which appeal. So see, opening paragraph will be MFA number 340/2020 has been filed by the wife against judgment and decree dated so and so, by which and you are sure that yes, 3442 is for by which petition filed by the respondent stroke wife under section 9 of the Hindu Marriage Act has been dismissed, right? So therefore appeals are disposed of. Yes. Nobody is appearing. You should argue, right? Nobody is appearing to oppose you. That's why we are asking. You should argue, right? Nobody to oppose you. Ah. Ah. Petition has been dismissed. Huh? That we are.
No, who instructed you that the parties are residing together? Then we will dismiss this appeal. We'll record your submission, dismiss this.
Where is the question of ascertaining when the appellant himself says that from whom will you ascertain? Good enough. Learned counsel for the, what's your name? This appeal has been filed against judgment and decree dated 18. Filed under section 13(1) within bracket small Roman 1B, small b of the Hindu Marriage Act has been dismissed. Paragraph. Learned counsel for the appellant submits that the appellant has instructed him that the parties are residing together after the impugned judgment and decree. Line below, the aforesaid submission is placed on record. In view of aforesaid submission, nothing survives for adjudication in this appeal. Same is accordingly disposed of. Yes. Ask him to sit down, your client. Ask him to sit down. Put behind the bars, arrested. What happened to that case?
What he says is, wife left his company in the year 2000. All of a sudden, she appeared in group. Her whereabouts were not known. Along with the son, she has gone. Just a second. What you have said in your petition is that wife has left the company in the year 2000. All of a sudden, she appeared in 2012. Obviously, she went along with the son, right? For 12 years, what were you doing? Were you not concerned about your son? Forget about wife. But you have stated in the petition her whereabouts were not known. Along with the son, she went. What did you do? What did you do to at least to trace the son? At least to trace the son, what you have done? That is understood. Now you have not stated anything in the petition as to what you did from 2000 to 2012, at least to trace your son. Nothing is mentioned in the petition. You say that all of a sudden she appeared after 12 years. So what were you doing till then? Thing. The petition says, petition government says that she left the company in the year 2000. In 2012, she all of a sudden appeared and demanded share. See, leaving the leaving the house of matrimonial house is one thing, but what is the cause for that? The husband is the cause for that, doesn't amount to desertion. If the husband is the cause for wife leaving the matrimonial home, it doesn't amount to desertion. She says that she has left. No, from her statement in the statement of objection, or from her statement in the evidence, are you in a position to pinpoint that she left the company without there being any reasonable cause? Show. All right. Show it. No, where it is admitted, we have to record that this fact is admitted in a particular paragraph, a particular statement, where it is admitted. Then it also enter. What for the son during all these years? It was this is left. Time was born in 1959. Birth of the child was not known. This is she left the company in 2000. Child was born in 1989. Which paragraph? Where she stated that she went on her own. Para? C. ABC. Read.
Sir, ever since the year 2000, the petitioner business of this person not even bothered to pay any maintenance, unless any subsistence allowance to the livelihood of the respondent in the child. The next statement is from the paragraph D method. Three of the above said that the petitioner find the respondent and the son and started to deal with them ever since. Thereafter, the petitioner returned back to stay with the respondent. This Malad from the year 2000 to 2012, Malad, they did not live together. 2012, Malad was only in the room, only to encash the check. There are immediate Malad, I give you a complaint to for the kidnapping and for this is the one. Police Malad does not take action. Counterblast Malad, she is a company. Police Malad registered the case and case is still pending. Fact remains, Malad, that has been Malad discussed with the private. From the year 2000 till today, except for a brief period of 1 month, 50 days to 1 month in July 2012, they are doing this. And I said,
When the child was born? In which year the child was born? All right. The respondent says the child was born in 1989. Let us accept that the child was born in 1994. Your petition government says you are not aware of the birth of the child till 2012. And you said that your wife has left your company in the year 2000. The child was born in 1994. And if she has left your company in the year 2000, how can you say that you are not aware of the birth of the child? And you insisted for DNA test.
and Malad helped his father relative. Relative of the respondent.
No, husband disputed paternity. Yes, the date of birth was 2018. So, Mr. Aware of the birth of the child. Husband insisted for DNA test, right? Why she would insist for DNA test? Disputed by whom? Husband. Correct. You disputed paternity. So at your instance, the DNA test was conducted. No, sir. You raised a dispute. Appellant raised a dispute. Husband. So what does it mean? Disputed paternity. I say you raise a dispute relating to paternity. What is the difference? The husband's contention that the child is not belonging to him. What does the report say? Then the husband also gave the blood sample. Husband also gave the blood sample for DNA test. So your accusation is found to be false. No, you accepted the DNA report. Who appears for the respondent? Basic facts we have understood is you suspected her fidelity. You doubted paternity. She went for the test. You cooperated for the test. The result is against you. So accusation is false. That accusation is serious accusation. Probably because of this accusation, she left the company. Cross-examine. That is not for us to. It's like this. A child is born from a wedlock. A child is born from a wedlock. Husband suspects the paternity. Then what the wife will do? Wife will go away from the company. While wife will move away from the company of the husband if this is the accusation. The accusation is serious. Let us assume that she deserted your company. For what reason? If it is on account of your treatment, if she has left, where is the need to hold that? Where is the ground to hold that she has deserted? Without any cause, with a permanent intention to put an end to marital relationship, if she goes away, then the court can say that there is a desertion. If you are responsible for wife moving away from your company, no, if it has not come on record, then there is no ground for granting a decree on desertion. If it has not come on record, for what reason she has gone out, then there is no evidence to say that she has deserted. They're all still pending. Those petition cases are still pending. No, criminal case. Government says that, that was born in 94. Look at your paragraph number 7 of the petition. What you have said is, wife left your company in the year 2000. She appeared in 2012. For 12 years, her whereabouts were not known. And in 2012, you realize that she has got a son. This is your contention. This is your contention. She understood. What you have said is, till 2000 she was with you, and you are not aware that the child is born. The child, according to you, is born in 1994, and according to respondent, is born in 1989. There is no foundation for your case. Because you disputed to convince you. You disputed.
The doctor has already in the final respondent. Some doubt with regard to the certificate.
An allegation is leveled against the wife, stating that the child is not born to the husband. Then what she will do? She has to bring scientific evidence. That's what she did. You did not accept her oral statement. She is sure. You are not sure. She is sure. Was no necessity. There was no necessity to go for a test, DNA test, provided there was no accusation. There was accusation, paternity was doubted. She provided the best evidence. Para number 7 of the petition says, para number 7 says, I was not aware that a son is born to me. What does it indicate? No, that fact we understand. 23 years marriage.
How much maintenance are you paying? Mr. See, the ground of desertion is not proved in the sense that the family court has recorded a finding that there is no pleading in your petition saying that the wife left the matrimonial home. The only thing is, no, please, this is the finding recorded by family court. If you see, there is nowhere, please tell us from the petition, where have you said that the wife has left the matrimonial home on her own volition? Because family court says that there is no finding. That's number one. Please listen to us, then answer. Then secondly is the only other submission which you are making is that it has been 23 years since the parties are living separately. So the only question which may arise for consideration is whether living away separately for a period of 23 years and conduct of the wife, if you can show from the record, in not attempting to join the matrimonial home, whether it would amount to cruelty. There are judgments of Supreme Court to say that if wife lives away for a long period of time and doesn't make any effort to join the matrimonial home, it will amount to cruelty. So point out from the pleading and the evidence whether, what transpired. Prima facie desertion, you point out where have you said, which paragraph of your petition you said that wife has left the matrimonial home on her own action with an intention to desert you, and your evidence, which paragraph? Which paragraph?
Start from the first line. The petitioner submits that. Wait for dinner.
The conduct of the respondent will not have clear intention of taking care of the citizen. Citizen is in need of the global cooperation of the citizen, not applying to his before or state of the citizen. Whether there is a citizen already, that's all.
It's displayed.
You say about this, there has to be, I think, the desertion for a continuous period of 2 years immediately before presentation. Filed it in 2013. According to you, the wife came back in 2012 along with DNA report and yourself. So then where is like?
After coming back in 2012, how long she lived together? Para number C, para number D, she says that she lived up to July 2012. Report. That respondent started to live with them ever since July 2012. Respondent submission, there is no introduction. Admittedly, the petitioner was living with the respondent as recently as in the no, in the cross-examination.
Yes. DC.
In para number 12, sorry, para number 6 of the statement of objection, countering your allegation in para number 12, the wife says the husband was living with the wife till December 2012.
3 para 6.
You said everything is admitted. It's not like that. No, it is her contention. She has never admitted that she lived separately all along. She says husband lived with her till December 2012. Then she has also filed a missing complaint. When husband disappeared, she filed a missing complaint. She filed a complaint. The case number is also mentioned, 422, crime number 4. That is a missing complaint. Wife files a complaint. All right. The beginning you made a statement that wife has admitted that she has been living separately all along. That is not the case. She has not. If she has admitted in the cross-examination, you can point out. In the pleading, there is no such admission. There is admission.
The petitioner has other stated being not only wife, was perfect. Lines of the said totally deserted the respondent and the state of RP. But since the year 2000, the petition has not even bothered.
Completed, I think, around 21 years or maybe 20 years after completing education. He goes to the father, makes a request to come back and visit with the wife and the son. Probably some sort of thing. He also produces the DNA. Response of son, that is an attempt to bring in sort of completion to admitted. Short period, then that's what we say. And this DNA report. And agreed to probably the from the cross-examination, are you in a position to point out that the wife left the company without there being any reasonable cause from the cross-examination of the wife? Chief understood. That will be replica of statement of objection. That is understood. Statement of objection in third person, chief examination first person. That is understood. In the cross-examination, you are not understanding the point. She may be living separately. No. She is living separately. That is understood, admitted. For what reason? For the fault of the husband, in case if she is living separately, it can't be construed as desertion. The circumstance or atmosphere in the matrimonial house is not conducive. If she goes out because of the attitude and conduct of the husband, you can't say that she is responsible for desertion. So, from the cross-examination, you must point out that there was no such occasion for her to go out of the company of the husband. From the cross-examination. Desertion understood, separation understood, may not be desertion, separation understood. So you point out this separation amounts to desertion because of the so many factors which is elicited in the cross-examination.
Not close the question with regard to the new location.
Page 26 of judgment.
It's an observation. I go ask this person what are the
Now, what happened to suit for party? What happened to suit for party? You are given the share? Share? No, you are given the share, or that is in challenge. Now, are you ready to give legitimate share to the son? Reasonable amount of alimony to the wife? So in that event, we can grant a decree for dissolution of marriage. Cannot contest the son's petition or son's suit for partition. End of the day is your son, scientifically established. And all these years you have not taken care of the son. No, son was living with the wife, mother. There was separation since 2000. So since 2000, the mother has taken care of the son. He is entitled to a share. Suit is decreed. Give him his legitimate share. A reasonable sum of compensation as alimony to the wife. Get a decree for divorce. Ask your client. You cannot contest this matter. You cannot contest that matter. You are seeking divorce. You are not ready to give share to the son. You have to be equitable. At the end of the day, is your son.
Please explain to him whatever. If your client is here, please explain it to him. We will take it up tomorrow. You speak to him. You speak to him. We will take it up tomorrow. So the impression gathered is the son made an attempt to bring in reconciliation after attaining 21 years or completing his graduation. He made an attempt to bring in reconciliation between the father and mother. He made an attempt. That is the impression that is gathered from the case.
Not just this case, settle that case, settle this case. In the interest of all.
Think about it, ask what is the appeal to list Monday. 17. You tell us, we will hear.
Okay, he said it. Criminal dispute, files of with the different kind of approach. Different approach is required. Human angle is required. You just to find it there is a procedural system. Any other.
Yes. Everything.
At BBK Younger Road, even if it's all 30, 40, right, and it's got several roads.
Yes. Yes. Nobody is for the appellant. We will hear you tomorrow. Tomorrow.
After that,
First they had appeared, then the appeal was admitted. Somebody has to appear so that we can. Next week. And for the appellant, mark his presence, learned counsel for respondent list in the next week.
My lord, I appear for.
Almost.
Please, great.
Thank you. Once I'm done with those by evening, I have to make comments. All cases tomorrow remaining. Appears. Who is the appellant? Don't seek tomorrow. You can seek an adjournment. No, but appellant is not there, right? If the counsel for appellant is present, we will adjourn. Otherwise, let it be. Tomorrow it will come. Please seek an. $60 this next week, right? You also don't want to argue. When do you want? Then. Huh? He's not there. Yes. He doesn't know which case you are telling. You are better informed about him. She is making a statement. Hey, Mr. Adipati, she is saying that the respondent has taken away brief from you. Is it correct? How she knows?
My lord, serial number 62, my lord.
This is 57. Where is your gown? Are you? We hope that you are wearing the gown, right, Mr. Huh?
Sir, where is your gown? You are not in proper robes.
Who this, we are telling you, 62.
Advocating through VC.
Please, my
Where is
lord.
your gown?
I'm at home office, my lord. I don't wear a robe.
Home office doesn't mean
Gown
that
is
you
not
will appear
exempted.
without gown. This is High Court, we will not permit.
No,
All
every-
rules, like,
I used
no, this is video conferencing is not meant to seek an adjournment sitting at home office without wearing the gown. We will not permit your appearance. So therefore, no question of adjournment. So, yes, sir. So then we will hear matter tomorrow. There is some reason we are getting up early today. It's not that tomorrow also we will get up. Tomorrow we will sit till 4:45. For some reason we are getting up early. We will hear you tomorrow, right? That is not appearing. All cases tomorrow.